first matter coming from the court this morning is the state of Ohio versus Norman Protsman. Is that correct?
Yes.
The appellant has waived, so we just have the state of Ohio here for your 15 minutes of fame this morning. So I have read the briefs and we're ready to proceed when you are, sir.
Thank you, Your Honors. Good morning. I am Brian Bremer on behalf of the state of Ohio. Given that the state is the appellee in this case and that the appellant waived oral argument, I will try to keep my remarks brief. I think it's important to emphasize the precise issue before you in this case. It's actually a fairly narrow one. At the suppression hearing, they said that the only issue before them was whether or not the field sobriety tests were administered in substantial compliance with the NHTSA guidelines. And what that means is that the suppression hearing was not about whether or not the stop was permissible. It was not about whether or not the officer had probable cause to arrest. And it was not about whether or not the breathalyzer was administered appropriately. So the only question here is about whether or not the results of the field sobriety tests from a scientific standpoint are basically admissible evidence. And with that in mind, the standard there is whether or not these tests were administered in substantial compliance with the NHTSA guidelines. The appellant has stated that he gives some lip service to the idea of substantial compliance, but for the most part, he actually is arguing for strict compliance. He says in his brief at one point that the only way to ensure substantial compliance is to actually have strict compliance, which is obviously not true, and it's not the standard in the state of Ohio, and it hasn't been for well over 14 years. So and it's unclear actually what he believes would be a substantial compliance and how this fell beneath that. He doesn't actually develop that argument. He focuses solely on the idea that the rules require certain things. These certain things weren't met, therefore it wasn't strict compliance, therefore it wasn't substantial compliance. That argument is incorrect on its face, and therefore, given that that's the only argument he really articulates, that's reason enough to overrule his assignment of error. However, he does point to a couple issues that he believes are issues with the one-leg stand and the walk-and-turn test. And in that case, he says that the officer did not ask whether or not there were any medical conditions that Mr. Protsman had prior to administering the test. And what is in the record is that is not an actual requirement to administer the test. It doesn't go to whether or not the test itself is administered correctly. That would go to really more the weight of the results of the test subsequently. And there's no evidence in the record that Mr. Protsman actually has a medical condition. The only indication is that his counsel during the suppression hearing comments that would it surprise you to know that he has this, which again is not evidence. And so at this point we don't really have any indication that the failure to ask whether he had a medical condition had any effect on the test at all. But furthermore, it's not required. The 5th District is held as such, and this district has also noted the fact that if we start requiring, saying you can get out of the test by claiming medical conditions, officers would never be able to administer these tests because anyone could claim a medical condition, which the officer would then be unable to actually verify at the time, and you could basically drive drunk whenever you wanted to.
Well, but like you just said, that would go more to the weight, so the officer knowing would be able to take that consideration in how to evaluate how they're doing, whether it's accurate or not. I mean, the officer could still think that, this is not being manifest, or this is nothing to do with the medical condition, it's to do with intoxication.
That's correct. And again, in this case, then, when you look at the actual facts, and the idea of whether substantial compliance is it's a case-by-case factual inquiry in many respects. In this case, on the one-legged stand and the walk and turn, he was unable to follow instructions. He was swaying. He was walking off the line. He would start and stop at tests. There are a lot of things he was doing in this case that were indicative of intoxication. And there's no complaint about the actual instructions or how the test itself is administered beyond not asking this question beforehand, which again, the testimony is that is not a requirement under the NHTSA guidelines. It is merely a recommendation, but it's not a requirement to actually comply with the NHTSA standards. The other issue we have is the horizontal gaze nystagmus test. And from what I can tell, the complaint from the appellant is this. He says that the officer did not run his finger back and forth the required number of times, and that the officer was looking for smooth pursuit of the eye to indicate intoxication as opposed to lack of smooth pursuit. I will point out that during the direct examination, the officer is very clear about what he's looking for. That he's looking for a lack of smooth pursuit. When you read what he says, he's talking about the fact that he's looking at the eye and he's looking to see if he smoothly pursues, but it's for the lack of it that he's actually going to grade him on. On cross-examination, there's some back and forth, and the best I can tell is the officer got confused about what the question was. And the court ultimately found that she believed the officer had complied with the standards on that issue, and because it's a factual inquiry, whether you believe the officer's testimony or not, that's something that this court really needs to uphold the trial court's decision, unless it's not supported by competent, credible evidence, which the direct examination testimony of the officer would be in this case.
He was wearing a body camera.
He was, yes.
Was the whole recording played for the court?
Yes.
And everything was caught on the camera?
Yes, and the court observed, watched it, and that was the basis of the court's, the court's weighing the evidence in favor of the officer. And I will also point out in the appellant's brief, he talks about how the officer doesn't comply with certain requirements of the NHTSA guidelines, but his evidence for that all comes from his counsel's closing argument in the suppression hearing. He doesn't actually point to any testimony or anything in the video that supports that. And as the court points out, when you watch the video, the officer actually does hold the stimulus out to the side for the length of time he's supposed to. As for the number of times that the officer runs the finger back and forth, it is fewer than the guidelines require. The officer said, though, that he did it enough to see that he was not pursued. He lacked smooth pursuit. That the nystagmus was onsetting before 45 degrees, and that he actually had the nystagmus during the test. So the officer saw all of the clues during the times he did the pursuit. And it's not like he only did it once or twice per eye. I mean, he did 6 passes on each eye. So this officer clearly was not just rushing through this. He clearly took his time, and there's no argument about why only doing it 12 times as opposed to 16 is somehow a failure to substantially comply with what the test requires. And absent the actual argument on this point, there's nothing really for the state to respond to. And this court has repeatedly pointed out, it's not your obligation to root out whatever argument that the opponent really could be making on this.
Being devil's advocate, isn't there a reason that NHTSA has 16 rather than 12?
I would say yes, and the answer is that it probably results in better indications of of intoxication. And the one thing I would comment on is that my understanding of the NHTSA guidelines is the more you do these tests, the more likely it is you're going to see the indications. It's more to make sure the officer doesn't wave someone through than that's intoxicated, as opposed to the failure to do. If you see the signs before you do all the tests, that's already covering what the reason for doing more tests would be. But that's outside the record. That's not in this record, the idea.
Speaking of record, was the NHTSA handbook put in the record in this case?
Yes, I believe it was submitted as on a CD.
And does the state even need the HGN in this case?
No, that goes to the issue of what's actually before this court, which is, this is such a narrow point, and even assuming there's something wrong with the HGN, the walk and turn and the one-legged stand would both come in, and that's on top of the fact that the officer had received an information from dispatch that someone was drunk at a gas station driving a silver car. He observed this silver car driving from that gas station. He saw the car go left to center. When he pulled him over, he observed an odor of alcohol coming from the driver. The driver's eyes were bloodshot and watery. He was slurring his speech. When he got out of the car and was doing the horizontal gaze and nystagmus test, he wasn't following the instructions. He was turning his head side to side, and he was swaying. He wasn't able to stay upright. And all of that is really strong indications of someone being too intoxicated to operate the vehicle. And as far as whether or not the officer didn't do enough passes, the fact that that Mr. Protsman didn't follow his instructions is not, that's unaffected by whether or not he did enough passes. He was turning his head, so he had to restart the test. And so, and even again, even if this court were to find a problem with the HGN, the other two tests would still be fine. And even beyond that, the question was only whether or not the results of the test would be admissible, not whether or not there was probable cause to do the arrest. So the question of whether the arrest was permissible is now outside the scope of this court, and frankly, it's a resolved matter as far as the suppression issues are concerned. So really, it's only a matter of, this is all about admissibility of evidence at a trial if there is one. But he already pled no contest and was found guilty, so I'm not sure exactly what would change if the HGN was suppressed at this point. But again, I don't really believe that the HGN has a significant issue in it, because he was confident he had done it enough to actually observe what he was supposed to observe, and that he did not believe that he needed to do the additional tests to substantially comply with the issue. And again, they've not really developed the argument on that point. So, unless there's further questions, the state would ask for you to overrule the assignment error and affirm the decision of the activist report. Thank you very much.
Thank you very much for your presentation today. The court will take the matter under advisement.